Have you ever wondered what would happen if you were unable to make important life decisions due to illness or injury? The thought can be unsettling, but planning for incapacity is crucial for both you and your family. Today, we're going to talk about essential steps that you can take. I'm Ethan Huizenga, attorney at the Huizenga Law Firm, and your host on Siouxland Senior Planning. If you want to be prepared for all of life's uncertainties, make sure you hit the like and subscribe buttons below, and we'll keep you updated with timely and useful advice. First things first, what is incapacity? A couple of weeks ago, we talked about capacity on the show, and we decided that capacity is the ability to understand a decision or perform an act. If incapacity is the opposite of that, then it means that you've lost the ability to manage your own affairs. You can no longer make decisions or perform certain acts. Generally, incapacity might be the result of physical or mental impairment. It could be temporary, or it could be more permanent due to a condition like dementia. One of the simplest and more straightforward ways to plan for incapacity is to execute a durable, general power of attorney. This document allows you to appoint someone to stand in your shoes and make decisions on your behalf regarding your financial affairs. That person will have the authority to sign documents for you, and they'll have the ability to manage your finances. They'll also direct the use of your funds to make sure that your needs are provided for. Another crucial document for incapacity planning is called a healthcare power of attorney or medical power of attorney. In a power of attorney like this, we're creating an advanced directive appointing someone to make decisions regarding our physical care. Putting a healthcare power of attorney in place can be extremely reassuring for both you and your family because it ensures that the right people, someone you trust, will take care of your medical decisions. Living wills are also significant in incapacity planning. A living will is another form of advance directive that lays out your wishes regarding end-of-life care. Having a living will in place can take a lot of burden off of your family during an already stressful time. Using a living will, you can outline what kinds of treatment or care you want to have or don't want to have, making it easier for everyone involved. Another tool you might want to use to plan for the possibility of becoming incapacitated is called a revocable living trust. Using a revocable living trust, you can set aside certain assets and appoint a trustee to manage those assets. You can find additional episodes about using trusts in your estate plan in the previous episodes of the show. Using a revocable living trust, you can create instructions and provide direction about your wishes regarding your property in the event you become incapacitated. Using all four of these tools together, you can create a comprehensive plan for how your affairs should be managed in the event of your incapacity. Now, one more thing. When is the best time to plan for your incapacity? Well, the answer has to be before you need to implement the plan. Simply put, when you're in good health, you're in the best position to make good decisions about your financial and medical or personal care needs. If you wait till an emergency arises, you might be under stress, which can affect your capacity, and that makes it more difficult to make good choices. If you're feeling overwhelmed about the decisions you might have to make and the options you have to choose from to deal with incapacity, remember that you don't have to navigate this journey alone. At Huizenga Law, we offer experience and guidance to help you make plans for your future needs. If you found this episode helpful, make sure you like and subscribe and check back in next week for our next episode.